Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Elloian. Our show topic today is sexual assault, recent judgments, and Me Too. Is America moving closer to equal rights for all? Our guest is Attorney Wendy Murphy. She is a former prosecutor now working as a victim's advocate, an impact litigator to assist abused women and children, bringing change to how courts, legislators, and the public view violence against women and children. She has written numerous briefs in both federal and state court on sexual assault, regarding violations of civil and constitutional rights and taking place on college campuses and in the workplace, many on the issues of first impression in Massachusetts and around the nation. She is an adjunct professor of sexual violence law at New England Law Boston and often appears as a legal analyst for a variety of news outlets, including CNN, PBS, and Fox News. Her book, And Justice for Some, is a riveting compendium of insights on how lawyers and judges let dangerous criminals go free. Let's welcome attorney and professor Wendy Murphy. Welcome, Wendy.
Good to be here.
You say in your book, like I said, I couldn't put it down, that judges often go easy on criminals. Tell us what you have seen in your career.
Oh, how many hours do we have? It's hard to choose one example of judges that go easy on criminals, but I think the statistic that shocks most people is that on average in this country, rapists spend less, let me put it this way, 2% of rapists spend even 1 day behind bars. 2%.
That's unbelievable.
I know. And we tend to think about rape as the crime that everybody gets life in prison for. I mean, that's kind of the myth. And there are lots of laws that say rape carries up to life behind bars. But what I saw as a prosecutor was time and again, probation. And for me, what it felt like was an expression of our legal system in terms of its opinion of the value of women's lives and bodies. And I took great offense. I just routinely objected, and the judges hated me. The judges would yell at me, Ms. Murphy, please. One time I said, to the judge, you can't do that. This is really an example of a case when I was a prosecutor that changed my career path and really put me on this trajectory of doing impact litigation now on behalf of abused women and children. The judge said, I said to the judge, you can't do that. That's not fair. That's not how you treat men. That is not how you've treated other types of crime victims. You did not do that to the robbery victim and so forth. And I did that a lot, actually, but on this one occasion, the judge said back to me, pulled his glasses down on his nose, I'll never forget it, and he said, Ms. Murphy, you are the government. Your job is to state the law, not complain about it. If you want to change the law, you have to get a different job.
Oh my goodness.
And so I did. I mean, I took him very seriously. I said, well, I don't agree with you. I think if I'm a prosecutor, I represent the people. I should have the authority to speak on behalf of the people when the court violates the people's interests, or when the court does something that's out of sync with what I think the law requires. Because the defense attorney standing next to me does it all the time. Your Honor, I know that's what the law is, but here's what it ought to be. That defense attorneys get prizes for that. They get Lawyer of the Year awards for that. When I did it as a prosecutor, I got admonished, and I didn't like that.
Well, they can fabricate too, and this is what bothers me. There's not equal footing for both defense and prosecutors.
Yeah, and that's not always incorrect. I mean, I see a justification for the imbalance there, that if you're the government taking away someone's liberty, you should be held to a certain standard, and to some extent, it should be a higher standard precisely because you have so much power to take away a person's liberty. But the fact that the government should be held to a higher standard doesn't mean the defense can lie. That's kind of a little bit too far. Neither side should lie. But in my career, time and again, whether it was in a court of law or on television or virtually anywhere in connection with a case where the defense wanted to win, and they always want to win, the lies came out, and they came out without anyone saying, You can't do that. That's unethical. That's illegal. You have a Fifth Amendment right to remain silent if you're charged with a crime. You do not have a Fifth Amendment right to lie. And yet we have no checks and balances for lies. If the government lies, if I as a prosecutor lied to the court, I could be sanctioned, I could lose my license, I could, there are so many sanctions that I don't even know where to begin, but the court could suppress the evidence. If I behaved badly in any way, the court could say, I hereby punish you by dismissing the charges against this defendant. Lots and lots of bad things can happen. Therefore, prosecutors, generally speaking, are afraid to lie. Doesn't mean they never lie, but they're afraid to lie. They're much more likely to tell the truth. Defense attorneys, they lie, and their clients lie because nothing happens. You can't add the evidence or add extra evidence against the defendant because he lies. That would be unconstitutional. You can't even punish the defense attorney for lying because the courts mostly say a defense attorney has a right to lie because he can do anything he wants in the name of defending his client's rights. That's where I write my book. That's what I write my book about, and that's where I draw the line. There's no such thing as defense at any cost. If the cost of that person having a fair trial is lies are okay and the subversion of truth-telling is okay, it's all about gamesmanship and winning, right, then we have a really big problem in this country, and we do.
Yes, we do. It seems to me, intuitively, it's an ethical violation. I mean,
but it should be more. Because ethical violations don't really lead to much by way of sanctions.
It should be more.
And a lawyer would say, fine, get me in trouble with the bar. File an ethical complaint. I'll just pay the fine, and I'll do it again. I'll factor it into the cost of doing business. It has to be more than an ethical violation.
And I think people don't understand when you see a defense attorney on the courthouse steps and he's advocating for his client, he pretty much says anything he wishes. However, you don't see the opposite. You don't see the prosecutor out there usually saying much if anything at all.
That's right. For the reasons I just said. Well, for the reasons I just said, the prosecutor can get in trouble. The court can say, I'm going to dismiss the charges because you shouldn't act like an advocate in the way that you did. You're supposed to represent the people. You're supposed to be balanced. You're supposed to be restrained. You're really not supposed to advocate for individuals ever. And that's true. As a prosecutor, if I saw a victim be disrespected and I tried to object on behalf of her individual rights, the court would say, you have no authority. You're not her lawyer. You're the people's lawyer. And the people's lawyer has to play by a higher set of standards. And I respected that. I did. But it drove me crazy that the defense attorney wasn't subject to the same rules. Not even close. Not even close.
So how does a victim's advocate play into this whole paradigm here, what you're doing in the courtroom?
I'm mostly a disruptor, and I do it in very unapologetic ways. You know, I have to be fearless about it because the system doesn't want me to do it. Often I'm writing on a blank slate. You know, as a lawyer, we get forms in the back of the book. You motion for this and a motion for that. There's always a form, or someone's done it before, and you can borrow their format and put it into your case. That doesn't exist for my cases. I always have to write from scratch, not only because much of my work hasn't been done before, but the system doesn't want me to do it, so they're not going to make forms for me. So I tend to not only do very creative work, but I do work that when the court sees it, they say, I've never seen this before, and that makes them a little uncomfortable, and I'm always prepared to say, that's fine, Your Honor, of course you've never seen it before. But it's important that we talk about the basis for my motion or whatever it is. And invariably I'm citing like the due process clause in cases from the 1800s because it really does go back to the most foundational doctrines in law when you talk about fairness and due process.
Now let's talk about due process. A lot of people don't understand this, that these kind of sex crimes cases get.
Something bad happens to you in a court case. If you feel like it was an injustice, it probably was. You may not have the language to call it some particular legal violation. You may not know your rights. It's very hard to advocate for your rights if you don't know what your rights are.
Right.
So on the back of my business card, I actually have a list of rights that I give to my clients, and I say, just read this. And if somebody asks you a question that you don't have to answer, because especially as a rape victim, the police or the defense attorney.
Miranda for women.
That's what I have on the back of my business card, victims' Miranda rights. And it's not a Miranda right in the traditional sense. You're not refusing to answer questions on the grounds that it might incriminate you. You're refusing to answer questions that are irrelevant. I'm not going to talk about my past sex history. I'm not going to talk about the fact that I smoked pot 5 years ago. I'm not going to talk about pregnancies. I'm not going to talk about whether I've ever had therapy before, because that's irrelevant. All you need to know is what happened at the moment in time when this rape occurred.
But women are bullied into giving up those records.
They're not always bullied. They are so eager to comply, and they don't want to appear to be hiding anything, so they tend to just turn stuff over. And I always advise them, once you do that, the cat's out of the bag. It's very difficult to stuff it back in, and the defense attorney is basically looking at a treasure trove of irrelevancies about your private life that have nothing to do with the case. But because you shared it, it's sort of presumptively fair game. So I teach victims to say, when they're asked inappropriate questions that aren't related to the moment in time when the rape happened, I say, respond by saying, don't say, go to hell, how dare you ask me that. Say, I'm not going to answer that question because it's not relevant. Just teach yourself to say in a very respectful way, I'm not going to answer that question because it's not relevant. If a judge wants me to answer that question, the judge can order me to answer that question at a later date. But for now, I'm not going to answer that question. And that protects the integrity of the case, which, by the way, increases the likelihood that one day it might be prosecuted. Because most of the time prosecutors decline to file charges in rape cases. It's because they've got this mountain of irrelevant private information, and they say, this is kind of messing up the evidence. Mind you, that's not a legitimate reason not to file charges, but it gives prosecutors an excuse not to file charges. So I like to empower victims with a little bit of legal knowledge, and not only that, but the power to hold prosecutors and police accountable. Why are you asking me that question?
Right.
What business is it of yours? I'll give you an example. I represented a woman in Nebraska a few years ago. Her name is Tori Bowen. She was brutally raped and drugged by a stranger she was at a party near her college. He secretly drugged her, and when she passed out, he took her to his apartment and abused her for hours and hours and hours. When she woke up, she was covered in vomit. She had no idea where she was, and the guy was charged. It was his third rape that he was charged with. And in that case, the judge told her right before trial that during her testimony, she was not allowed to use certain words. She couldn't call herself a victim. She was forbidden to use the word sexual assault. She was forbidden to use the word rape. She was forbidden to call him an assailant. She had to refer to the rape kit as what was called the sexual assault kit. She was required to call the sexual assault kit the sexual kit, and she had to call the sexual assault nurse examiner the sexual nurse examiner, like she was a gynecologist. I was outraged. I flew down there.
That's outrageous.
It's not only outrageous, it's blatantly unconstitutional. You cannot tell a private person who's testifying in a court of law what words to use to describe what happened to them. If she wanted to say it was peanut butter and jelly instead of rape, she can choose to say peanut butter and jelly, and the jury will decide how they feel about her testimony. It's absolutely illegal for a judge to censor a person describing what happened to them. What happened is I go down to Nebraska, I file paperwork, and I say, due respect, you don't have the authority to do this. You can't do this. It's a violation of the federal Constitution for you, under state law, to tell a person how to describe what happened to them. You can't do it. He knew I was from Massachusetts, so he waited me out. For 5 days, he just refused to have a hearing. And he knew I had 5 kids, and I wasn't going to stay forever. Eventually, I had to go. And I've done so much of this work over the years. I told my client, as soon as I go to the airport, he's going to call you in for a hearing. So let's prepare you for that. And I prepared her. And exactly what I predicted happened. I'm at the airport. He calls her in for a hearing. And she takes a stand, and he says, do you understand my order and what I've told you you can and cannot say? And she said, yes, I do. And he said, do you intend to obey my order? Because you can go to jail if you don't. Do you intend to obey my order? And she said, Your Honor, when I raise my hand to tell the truth, the whole truth, and nothing but the truth, so help me God, that's exactly what I intend to do. And he couldn't respond. I mean, how do you tell somebody, no, really, I'd like you to lie? He was so angry that she had that response. He slammed the gavel and dismissed all the charges. which is also absurd.
Right.
But it was good for me because I then sued him because the prosecutor refiled the charges, and I sued the judge, the state judge, in federal court. I sued the state court judge in federal court, arguing that the federal court should order him not to violate my client's federal constitutional rights, free speech rights, under the First Amendment. And the federal court, again, it was Nebraska, the federal court was so angry that I was so audacious to sue a state court judge. But I was right. I was correct, and I had a right to sue him. It wasn't for money. It was to get an order stopping him from doing that at the next trial. But the federal judge was so angry that he just slapped me around in the decision eventually. But he said this, which is very interesting, and it's really the nature of the work I do. He said, it is disturbing that a lawyer from Boston would come to Nebraska federal court to do her gender politics. Mind you, I thought I was doing the First Amendment.
Right.
But anyway, but then he has a footnote. On the other hand, it is profoundly disturbing that a judge in a rape case would order a rape victim not to use the word rape. Indeed, it is reminiscent of the kinds of things we hear about from countries where women are oppressed and so forth and so on. And I was so thrilled. I mean, all I won was this footnote, because he then dismissed the case and screamed and yelled at me, but that footnote was a big victory. But it so outraged people that I had the audacity to stand up for this woman the way that I did, even though I was correct. A senator, a state senator in Nebraska, to mock what I did, filed a lawsuit against God.
What?
And then went on television, including CNN, and said, if a rape victim can sue a judge, then I can sue God. And he just went crazy with this absurd lawsuit.
That is absurd.
I know. I said, how are you going to get service on God, right?
That's right.
But more importantly,
I wouldn't want to be the one to do it either.
no, because you might not come back.
That's right.
I was very moved by all the effort that was put into that case, because it showed me that what I was doing was making a difference.
Yeah.
So you don't have to win to make a difference. You just have to provoke people, you have to irritate people, you have to change things a little bit. So that inspired me. I know that sounds like, oh, well, you didn't win. Well, we did win, because that footnote then stopped all judges in Nebraska from ever doing that again. So it was a win, and in my opinion, it was a win in the sense that it taught me, and it taught a lot of victims, because it got a lot of publicity, that winning the issue isn't as important as standing up for yourself, making noise, protesting, complaining, filing lawsuits against judges. All these things are what you're supposed to do in a democracy, but victims don't do it. Women are far too obedient. They don't know their rights. And even when they try to assert their rights, they're often represented by lawyers who tell them to just, accept the inevitable, be quiet. Lots and lots of victim advocacy groups in this country are really there just to manage victims and keep them quiet. And I'm the opposite. I'm saying, almost always, we're not going to stay quiet. And I'm not going to tell you to accept this injustice. We may lose in the end, but we will go down screaming. The fact that women are second-class citizens in this country always have been. Women are not equal under the Constitution. We have not yet won the ERA. 90% of Americans don't know that the ERA is not law, that we have not yet passed the ERA. It passed
Equal Rights Amendment.
the Equal Rights Amendment, which was passed in 1972 by Congress, was then sent to the states for ratification. An amendment doesn't become law until it's ratified by 38 states.
And just the other day, Illinois finally ratified it in
I was involved
2018.
in that. Yeah, I was very excited. I've been doing a lot of ERA activism recently. Nevada ratified in 2017. Illinois ratified 2 days ago. And that's up. Now we're up to 37. So we need only one more state. And we're thinking it might be Virginia. It's possible Arizona's up there. But we're close. We're very close. And I think it's absolutely doable. But what bothers me the most is that we can't rally women to fight for the ERA if they don't know they don't have equality. And what happened after 1972, when the ERA passed Congress and was sent to the states, is a lot of women just assumed that because it passed Congress, it must be the law. And there really wasn't good public information out there about what we really need to do to make it become an amendment to the Constitution, to make it actual law. The law of the land, not just pass Congress, but apply to all of us. So people don't realize that as of today, we're sitting right here, you and I, are second-class citizens. What that means is if we go into court to try to enforce our rights, the court can say, well, yes, you weren't treated equally, but that's okay. You're not entitled to equal treatment. Equal Means Equal is one of the groups that I work with. They're extremely good because they refuse to take money that comes with strings. Equal Means Equal has been at the forefront of a lot of this ERA work. They're involved in a lawsuit that I filed against Betsy DeVos, the Secretary of Education.
Yeah, let's talk about Betsy DeVos and the new campus
Oh, she is a nightmare.
laws.
She's a nightmare, but again, some of the women's groups in this country are actually not really opposed to what she did. And let me explain a couple things. What Betsy DeVos did last fall was which was September of 2017, she issued a document, which is sort of like a guidance document, not a law, but a document saying schools must subject violence against women like sexual assault, all sex-based harms, which is a form of discrimination. So she basically issued a document saying sex discrimination on college campuses should be subjected to second-class treatment, not on par with race discrimination, national origin discrimination. Historically, Title IX, which a lot of people think of as a sports equity law, but it isn't. It doesn't say anything about sports. It says that there shall be no different treatment based on sex. Women must be treated equally, equal access, equal treatment for sex-based harms, equal treatment of sex discrimination.
And this is all in education.
In
Title
education,
IX, yes.
in education. That's what Title IX says. But pretty soon after it was enacted in 1972, there was a lot of propaganda misframing it as a sports equity rule. And that's one of the reasons I didn't think it applied to me. I was never very athletic, but I was misled to believe that Title IX was about sports. And it was only as a young lawyer that I read it and said, wait a minute, I got duped. This is about equality in
Civil
education.
rights.
Civil rights. This is exactly the same law that protects civil rights for black people and Jewish people and so forth. So I started doing Title IX activism in the early 1990s, and one of the things I did was particularly target cases where I could get systemic change, because if you file a federal investigation against a community college in the middle of nowhere, the rest of the schools aren't going to pay attention. So I won a landmark case against Harvard. It was really the first case of its kind in the country under Title IX in 2002. And people start paying attention, because when Harvard gets in trouble, everybody notices. And the schools started following, in line with what I had done in that case. And that led to more knowledge, more awareness, more understanding. It really was, in 2002, the first time the public started to understand that sexual assault is a form of sex discrimination and that it's covered by Title IX. Well, women started to rise up and say, wait a minute, I was sexually assaulted. You didn't treat the sexual assault that I suffered the same as racial assaults. You treated me like crap comparatively. Why didn't you tell me this was a civil rights issue? Started complaining to their colleges and universities. In response to that, Betsy DeVos comes out and says, it's okay for schools to subject sex-based harms to second-class treatment. So I sued her because I said, you don't have the power. You are not Congress. You cannot subvert Title IX. You can enforce Title IX, but you cannot subvert Title IX.
So
You're just the Secretary of Education, nothing more.
What's the outcome?
It's still pending. I sued her in federal court in Boston. There are only so many women's rights groups that are actually dedicated to equality. Equal Means Equal is at the forefront on this, and they need to be in the lead. They need to be in the lead because they're the only ones, they're the ones who made it happen in Illinois. They're the only ones that have said, I don't want your corrupt money. We're not going to do something harmful to women. And it's important that the public understand these corrupt influences are out there. Sexual access to women's bodies and control over women's lives has always been a bipartisan male entitlement. This is about male supremacy in the Constitution. That is not a left versus right issue. That is a female versus male issue. And
that's why we need the amendment.
Yes, and make no mistake, there are a lot of really good men on our side. In Illinois, the initiative was led by a Republican and a Democrat. So it's really, now it happens to be that Republicans in the South tend to be urgently voting against this when it comes up, and Democrats in the South are, for the most part, in support.
Well, from what I've read, they're making this an abortion issue,
Which it isn't. Which it isn't. No, an abortion, I mean, women's rights and abortion are connected, but in many states where they have equal rights under the state constitution, which is true in Massachusetts, it really hasn't affected abortion rights. In other words, if you're not equal under we're not equal under the federal constitution, we are equal under the Massachusetts constitution, and yet abortion is, still what it is. It's somewhat restricted, it's whatever. So that's a myth that all of a sudden abortion up to 9 months will be mandatory.
It's an excuse.
No, it's not going to happen. But we do have to be more sophisticated as women. We were very sophisticated in the early 1920s when Alice Paul first proposed.
Suffrage, yeah.
When Alice Paul first proposed the Equal Rights Amendment. We're almost 100 years. We've been waiting a long time.
A long time.
But Alice Paul's view back then was pretty contemporary. I mean, equality is not complicated. And that's all the ERA says. Equality under the law shall not be denied on account of sex. That's not complicated. It's basically one sentence. And everything people said 100 years ago is still being said today, on both sides of the aisle, that men are saying, not all men, but men who are against ERA and women who are against ERA are saying it's not going to be good for women. It's going to be bad for women. They might have to go into combat. First of all, most women who are in the military actually do want to go into combat, and they don't like being told they're too fragile. And if anything, nobody should go into combat. If you don't like combat, it shouldn't be good for men either. But this notion that after 100 years, we still have people saying that women are frail and fragile and so forth. We don't need protection. We need people to understand at a very basic level that this is fundamentally about male supremacy, sexual access to women's bodies and control over their lives, the ability to beat your wife without getting in trouble. All of this is part of male supremacy. Violence against women is the #1 expression of women's inequality, because here's equality, here's second-class legal treatment, and that space in the middle, that's where violence against women happens with impunity under the law. Because if you go to court to try to ask for protection from this violence, the court's going to say, you're not entitled to it because you're not up here.
Right.
So that space is why we have such high rates of violence against women in this country. It's legal to beat and rape women in this country. It is legal because we're not equal. It's that simple. And why is that not a good reason to support the ERA, male or female?
Well, this has been a fascinating overview. I want to thank you for enlightening us.
We're done already?
I want to thank you. And if you can provide some information to our viewers on some of these organizations that you find support ERA, we'd be glad to pass that along.
Thank you. And if you are going to buy my book, which we have a copy right here,
yes.
Don't buy it from Amazon because it's not the current version and the person who put it there is not the owner. It's me. Believe it or not, somebody stole my book and sells it on Amazon. My book can be downloaded at my website, wendymurphylaw.com. It is the updated edition, and a lot of people are making money on Amazon, not me.
And the book is And Justice for Some.
Not women and children. Some means not women and children.
Thank you, Wendy.
Thank you, Mary Kay.
I want to thank our guest, Attorney Wendy Murphy, for sharing her insights and opinions on sexual violence and the law. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guest, visit The Legal Edition online at thelegaledition.com. As always, this information is for general educational purposes only. It is not to be construed or relied upon as legal, business, or professional advice, and please consult a qualified practitioner as to your legal, business, or professional needs. And don't forget, subscribe online, follow us on Facebook, YouTube, and Twitter.